Good morning. Happy Thursday. It's Thursday. That's the day. Uh, I just want to. This is gonna be my last video on Officer Greg Anderson because it's been beat to death. I have made the legal arguments. There's just a couple legal arguments that I want to make that haven't been addressed. They've been raised either last night or yesterday, I think, in my comment section. I didn't check exactly. I just saw them this morning. So there's just a couple arguments I'm going to make, and then this is it. So get your kicks in here. To preface this, I just want to say that I have always been against shutdown orders from the very beginning. I have been mocked over my dislike of the shutdown orders. I value freedom over safety. I will take freedom over safety every day of the week. I understand that, I am in the minority, maybe not in this particular audience, but as far as the world is concerned, I guess I'm in the minority, and that's fine. I don't base my opinions on what the herd thinks. I think for myself. Thank you very much. You can go all the way back. The first video I made on this was April 17th. I haven't changed my opinion ever on this particular topic. The reason why I haven't made a lot of videos on it is because I make videos primarily about the First Amendment, primarily about First Amendment auditors. And if I'm not talking about the First Amendment or First Amendment auditors, I'm talking about legal topics that interest me generally, and coronavirus doesn't interest me. I don't care about it. It's not an issue that I really care about. The only time I started caring about it was when the shutdown looked like it was going to continue. They had the initial shutdown through April 16th. I found out April 17th that it was going to continue through May 1st. And I was like, this is bullshit. That's why I made the video. It's a political video, and I normally don't make them. But I haven't changed my opinions on the shutdown. But my opinion about the shutdown doesn't make the shutdown unconstitutional. I don't like it. That doesn't make it unconstitutional. What makes it unconstitutional is if a court actually finds that it violates some statute or some portion of the Bill of Rights. And to date, courts have not done so. I can make arguments for and against it. I think the arguments for it being unconstitutional, well, I think I just like them more. I think I'm just biased against them. I think they're stronger, but I think that's just because I'm biased against it. So I haven't changed anything on it, and I don't disagree with the sentiment of Officer Anderson. He wants freedoms. He wants the freedoms of the country to be restored. He wants places to open up, shutdown orders to be taken out of effect. And I agree with him on that part. That doesn't make it unconstitutional to have the shutdown orders. Again, that's for the courts to decide, not for Officer Anderson. Officer Anderson doesn't get to substitute his own opinion for the courts. And he doesn't get to be insubordinate without consequences. If he doesn't want to be a cop anymore, if he wants to say, I'm going to pick which orders I follow, which rules I enforce, then he doesn't have a job as a cop. They can't do that. Again, there are protections in place for cops, just like there are protections in place for military personnel. They don't require the lowest of privates to determine what is or isn't a constitutional order. Essentially, the way it works is if you're ordered to do something and you don't do it, you get brought up on insubordination charges. If you're ordered to do something and you do it, you only get charged with crimes if what you did, a reasonable man of average intelligence would have known it was a crime. If you're ordered to commit a crime that a reasonable man of average intelligence would know is a crime, that's the only time you get punished for it, because they don't expect you to interpret the fucking Constitution as a private in the Army. When you first take your oath and you go into the Army as a private, they don't expect you to be a constitutional scholar. You may not even have finished high school. They don't expect police officers to be constitutional scholars. Police officers are very good at what they do. I don't want to take away from what they do. They arrest people better than I would. They enforce the laws better than I would, because that's what their job is. They're professionals at doing it, but they're not lawyers. They're not judges. They don't have the tools that they need to do. So they are just like military personnel, they are protected. Unless it is a clearly established violation of constitutional rights, i.e., there is case law on the subject. Case law that is in their circuit at a circuit court of appeals level. If it is clearly decided in their circuit that that particular activity is a violation of constitutional rights, only then will they be held accountable. There's suppression hearings every day, but officers don't lose their jobs. They don't get sued over having, done a frisk that wasn't based on reasonable suspicion. You know what I mean? There's protections in place because the courts and the legislatures understand that not everybody's going to understand the nuances, the gray areas, and that people can't know and understand the gray areas. There are protections in place. So that said, I think we're all on the same page. I hope we're all on the same page as far as that's concerned. I do enjoy, however, the people who call me un-American and who think that I am the one who's trying to violate the Constitution when they are arguing for their interpretation of the Constitution to supplant the courts, for police officers to supplant the courts and to provide their own interpretations of constitutional law. I find that to be hilarious, hypocritical, and just shows you the intellectual processes that are going into this. These people haven't provided a scintilla of evidence, a scintilla of support for their arguments, whereas I have provided every evidence you need. I've given you case names, Marbury versus Madison. I've shown you the text in it. Even Officer Anderson agrees that Marbury versus Madison is precedent, and it does control our understanding of the relationship between the Constitution and lower laws. It does so because the Supreme Court said, and the Supreme Court also said in that opinion, the Justice Department, the Judicial Department gets to determine the meaning of the Constitution. So, come at me, bro, but if you're going to come, bring something to support your argument. Don't just say, well, I just disagree with you. Because you sound like a fucking idiot. Excuse me, you sound like a microcephalic. There we go. Microcephalic retard. Damn it, I can't say retard. You sound stupid. You sound like a pinhead. I'm not supposed to call people retard on YouTube. I think that's another fault in our society, by the way, just since I'm getting all political in here. I think it's a fault in our society that we think that everybody has equal value and that we think that everybody should get a participation prize and people shouldn't be told when they're being wrong and stupid. One thing I greatly respect my boss for is when I'm wrong, he looks at me in the eye, square in the eye, and he says, "You're wrong." I appreciate that. I like to know when I'm wrong. And you know what? He respects me because I don't argue with him. I walk back to my office, and if I know I'm right, I look up the case law. I find the case, the facts, the law that support my position, and I march back into his office, and I look him in the eye, and I say, no, actually, I'm right, and here is the proof that I have. Great working relationship. It's not a bad thing to be told you're wrong. It's a good thing to be told you're wrong because that gives you the opportunity, if you are a human being of any worth whatsoever, it gives you the opportunity to learn from your mistake and to learn what is right. Speaking of which, one comment in my comment section was that Officer Anderson was clearly protected by the First Amendment. Obviously, no argument was given, no case was cited, nothing was presented other than someone's just blanket opinion that clearly, well, if you say clearly in front of it, obviously it must be true. Clearly it must be true because he said clearly. Well, I did a video just recently, May 8th, where I discussed this in detail on a Matt Christensen response. And there are three basic cases that are controlling what people who are in public employment say, whether or not it's protected by the First Amendment. Pickering versus Board of Education, Connick v. Myers, and Garcetti v. Ceballo. I don't know. Ceballos, Ceballos, I think. Ceballo. I don't know. Anyway, of those cases, Ceballo, I'm going to call it Garcetti. Garcetti says that if you say it as part of your official duties, then you're not protected by the First Amendment. The employer, in this case, the Port Authority of Seattle, has the right to be able to control the speech of its employees in their official duties. Officer Anderson was in his patrol car on company time, on police officer time, paid time, in uniform, speaking as a police officer to other police officers. He was in his official duties. So I think he is not protected by the First Amendment. But let's just pretend, for the sake of argument, that a court will find that he was not speaking as part of his official duties. Pickering versus Board of Education. Well, Connick v. Myers says it has to be a matter of public importance. I think this is, so we can skip past that. But Pickering versus Board of Education sets out various factors that the court would then look at, assuming that they're not speaking in their official duties as a public official, assuming that it is a matter of public importance. Then you go on and look at how it's going to affect the working relationship between them and their employer, them and their supervisors and their fellow employees. And in this case, considering that he is advocating for insubordination, I think he's going to fail on that test. So he's going to fail, in my opinion, on the public duties portion, and he's just going to foul out right there. But assuming he gets past that hurdle, he still has a massive challenge in Pickering versus Board of Education. So no, I don't believe he is protected by the First Amendment. If he gets a real good attorney, maybe, but I don't think he is. And finally, because this video is running long, and once again, this is my final video on the subject, so if you disagree with me, well, you're just going to have to suck it up. Blue Bacon, I think it was. He said, I think Jacobson versus Massachusetts is going to be controlling on this issue, or something along those lines. And I may have been harsh on Blue Bacon from time to time, and I'm probably going to be harsh on him again in the future. I want to preface this by saying I don't watch his content. Apparently, he made a video on this. He talked about it later on in the comment thread, and he thinks that somehow makes him an authority on it. I find his videos just make me mad watching him if he's talking about anything beyond the scope of being a police officer, because he might be a fine police officer, and police officers are trained to do very police officery things, but they're not trained to be lawyers, and they're not trained to interpret case law and to issue spot and to deal with all these things that lawyers do. He is not cut out for it. He has talked about wanting to go to law school. I think that would be a boon for him. I don't think he's stupid. I just think he doesn't understand. So Jacobson versus Massachusetts, I haven't read it in a long time. I just saw it this morning that he commented on it, but I don't know if I did a video on it in the past or if I just beat up anti-vaxxers with it in the past, but it's a very common case that's cited to fight anti-vaxxers who think that somehow there is a constitutional issue with states mandating vaccines. But it doesn't apply to quarantines. And I'm going to tell you why. In quarantines, the issue is due process. The issue is, has the state provided you with the due process before they basically took away your liberties? Have they done that due process? And again, they need to show that you have been exposed to it. And if you've been exposed to it, if you could show that you don't have it, then they can't quarantine you anymore. If you could prove that you don't have it, they can't quarantine you. So essentially, they have to show that you probably have it, that you probably have whatever it is they're quarantining against, and that it has to be communicable. If it's not communicable, there's no gain to the state by quarantining you. If you don't have it, obviously you're not communicable. If you have it, but it's not communicable, then again, no state interest in quarantining you. So there are two Supreme Court cases that are on point as far as whether or not the state can do quarantine laws, and those are Gibbons v. Ogden, and I'm probably going to screw this one up. It's Compagnie. It's French. It's called French Company for Navigation on Water or something like that, versus the Board of Health for Louisiana, or Board of Health for the state of Louisiana. I'm not sure entirely which way it was, which way it is, but it's like Compagnie Française de Navigation de Vapor, something along the way. Anyway, Google it. You'll figure it out. Those two cases, they're both from turn of the century, like 1901 or 1895 or somewhere in there. They're both old cases, but they laid it out that the as part of the police power of the states can enact quarantines. But the question is due process. So you're not going to look at Supreme Court cases for guidance on this, unless you're looking at Supreme Court cases on due process, because it is a due process issue. Now, some people have been arguing, like my boss really believes, and I disagree with them, that the shutting down businesses is a violation of the takings clause. The government can't take your property away without compensating you for it. I disagree with him on that, but we're really going to be looking at Fifth Amendment kind of issues. I believe it's not a search and seizure issue. They're not seizing you. You're being quarantined. It's not a seizure, but it is a deprivation of your liberties, and so it would be a due process clause. Anyway, that's my story, and I'm sticking to it. Again, I'm not disagreeing with anybody who thinks that the stay-at-home order should be lifted. I agree. Stay-at-home orders should be lifted. I agree. For political reasons, I agree they should be lifted. But my distaste for the stay-at-home orders and all the other inane orders that aren't going to help, and they're just the nanny state trying to control us, aren't going to really do anything. I mean, just because I don't like them doesn't make them unconstitutional. One final thing that just crossed my mind. Common sense. I hear a lot of people say common sense, common sense, common sense. This requires common sense. And it's funny that these people think they're arguing common sense in favor of allowing a police officer to dictate what is or isn't constitutional. I just want to remind these people, because I'm sure they're coming from a very specific background. I want to remind these people that one of the things that people will try to do when they're taking away your rights is to argue common sense. If you haven't heard it before, well, look it up. Common sense gun control. What does that mean? It means they want to take away your guns. Common sense gun control is just saying that we want to substitute our judgment for your judgment and take away your guns because we don't trust you with them. Never mind the fact that you've owned these guns for years or whatever. Like, I've had guns since I've turned 18. I haven't shot anybody yet. I don't plan on doing it. Haven't robbed a bank. It's common sense gun control for me means you let me keep my guns, because I actually have stopped a home invasion of my home with my pistol. So I didn't shoot anybody. I didn't have to. I just pointed it at them. But it stopped the home invasion. So, these things happen. But back to my point, common sense isn't a good argument tactic. Because number one, if people disagree with you, they have their own common sense and they're disagreeing with you. You're just trying to say, use my common sense instead of yours. And if you can't formulate any argument better than, but my common sense is better than your common sense, then no one's going to care about your common sense because you're too inarticulate. You don't have a good enough argument to convince them. Now I'm really done. Thanks for watching. Have a great day.